Okay, in this presentations, I am going to present on topic maxims of equity. Hmm. Here, there are around 12 maxims of equity, which are given some authority, principles based on the honesty, based on the morality, based on the uprightness, and based on the principles of natural justice. Here, this has given authority to the judges, to the magistrates, to the court, or to the judiciary in dispensation of justice. That is, that's why they are the sum authority of the law based on the principles of equity. That is, here in these maxims we have to refer the definitions of the Solomon. Here, Solomon has quoted that maxims are the proverbs of the law and provide useful means for the expression of leading doctrines of the law in a form which is brief and intelligible. Yeah, these doctrines of equity law, it provides some authority to the court or the judiciary, and it is in the form of brief and it is the form of the intelligible. That is, it must be drawn by the court of judiciary based on their judicious power or based on their discretionary power, based on the heavy conscience. That is, here, that is the clear concept of the maxims of equity. In these presentations, I am going to present only four maxims. Equity will not suffer a wrong to be without a remedy. And number two, equity follows the law. And number three, he who seeks equity must do equity. And number four, he who comes to equity must come with clean hands. These four maxims I am going to present. Okay, number one maxims at first. Here, equity will not suffer wrong to be without a remedy. Here, this maxims comes under the concept of the U is just IV remedium. That means where there is a right, there is a remedy. That is, here, this is the basic concept of these maxims. Here, rights and remedies, they have the coexist. That is, here it is said in the SB versus White that the rights and remedies, they have the coexist. They have the relationship with each other. That's why when the law clothes a man with a right, he must have means to vindicate and maintain it, and a remedy if he is injured in the exercise and enjoyment of it. And indeed, it is a vain thing to imagine a right without a remedy. For one of right and one of remedy are reciprocal. It is clearly given under the concept of the ubi just if a remedium. It also cited in the SB versus White case. Whatever we have obtained in the English common law. That is. That's why that is the basic concept. Here, if somebody's right has been violated, that is. Now, the claimant, at the moment of the claiming, they have given some opportunity to justify by providing evidence, to justify by providing evidence before the authority. That is the right to defense their own rights. This opportunity must be given to claim their rights. Here, this is the comes under these maxims. Here, the equitable jurisdictions in England grew up from the deficiency of the common law and inadequacy of remedies provided by the common law. That is, whatever we have already discussed under the concept, origin and evolutions of the equity law in the previous presentations. That is, now this maxim covers equitable jurisdictions. Here, this maxim is the source of the entire equity jurisdictions. Now, whatever we are discussing, equity will not suffer a wrong to be without a remedy. These maxims cover the entire equity jurisdictions. That is, here, now, here, jurisdictions of the equity, we could be seen under the three concepts, that is the exclusive jurisdiction and the concurrent jurisdictions and the auxiliary jurisdictions. Under the exclusive jurisdictions, here comes the dispensation of justice based on the equity principles only. Here, whatever the rights given under the creations of a trust, it comes under the exclusive jurisdictions based only on the principles of equity. And concurrent jurisdictions, here both the provisions of the law and the equity principles, they must be complied with each other. In concurrent jurisdictions, here this can be exercised in case of the fraud, in case of the misrepresentations, whatever we got under the concept of the Indian Contract Act, under the voidable contract. Here, both the provisions of the law, both the provisions of the substantive law, and the equity principles, both are complied with. That's why, under this concept, concurrent jurisdiction, it can be exercised. And the third one is the auxiliary jurisdictions. Here, it comes under the add to the dispensation of justice on equitable principles. Here, this maxim provides that here these auxiliary jurisdictions for equity lends, it's add to the production of evidence which may be required in the actions at law. Here, these auxiliary jurisdictions, it provides some new procedure. That is, whatever the parties, they have claimed their rights. They must be given some scope to produce their legal titles, their documents before the authority, and to produce some witnesses for giving statements, for giving depositions, and for cross-examinations of these witnesses. This auxiliary jurisdiction provides about some new procedure that is, which is necessary. This could be sent in case of the causing of threatened nuisance and the threatened violations of the copyright and patent right. This concept come under the, and in case of the injunction order, that is here these principles of auxiliary jurisdictions about the procedure of the production of the title, production of the documents, and the production of the witnesses for giving statements and the for cross-examinations. Here, these auxiliary jurisdictions of equity provides about this. Here, now, this maxim led to the chancellor to intervene in the administration of justice in order to give relief where the common law gave none. That is, and to give an adequate relief where the one available in common law courts was inadequate. Yeah, if the provisions of the common law are not sufficient for the giving justice to the parties, then the provisions of this equity principles will be followed. Here, this basic concept we have got. Now the limitations of this maxim. Here, number one limitations. It provides that the maxim doesn't apply where the right in question is a moral one, and it is not capable of being judicially enforced. That is, but the court of equity only interferes when there is an invasion of legal or equitable right. It is the limitation that in moral rights and which are not judicially enforceable. In these cases, the principles of equity will not be applicable. And the second limitation is that equity doesn't interfere to remedy any wrong, where the right and the remedy both completely belong to the domain of the law. Here, second limitation, when both the right and the remedy are completely comes under the provisions of the law, then based on the public interest here, the equity principles, it will not interfere the domain of the law, the provisions of the law. That is here, and the number third limitations, it provides about the maxim doesn't apply where a party has destroyed laws or wife, that means give up his right to an equitable remedy by his own act or lashes. Yeah. The third limitation, it says about the conduct of the parties. If they have not been enforced in due time, if they are sleeping in their own right, that is the negligence by the party themselves. In these cases, the equity principles will not help such parties for giving justice. That is the basic concept of the number one maxims. Equity will not suffer a wrong to be without a remedy. We got the concept of this maxim. Now, next maxim. Next second one maxim. equity policy law. Here, here, this maxim means that equity is not a body of jurisprudence acting contrary to law, but rather a supplement to law. Here, this is expressly given that it is these equity principles are not the principles of law, which comes against the provisions of the law, but the principles of equity. It always tries to supplement, always tries to support the ordinary provisions of the law. It is. Here, that's why the code of century never claimed to override the courts of common law. That's why the provisions of the code of century, that is the principles of the code of century, it cannot, they have no ambition to override, to supersede the provisions of the ordinary code of common law. It only tries to support the ordinary provisions of the law. That is the concept of the equity policy law. Here, this maxim is understood in the two following respects. Number one, equity adopts and follows the rules of law in all cases where applicable. Here, these principles express that where a rule, either of the common law or of statute law, is direct and governs the case with all its circumstances on a particular point, a court of equity is as much bound by it as a court of law. Yeah. Number one says about it, the code of equity principles, they have to bound in cases in which the provisions of the law or the particular statute, they are directly applied in some particular cases. Only the judgment and verdict, only the verdict, that is the judgments, it will be based on the provisions of the, in accordance with the provisions of the law. That is the number one. Equity must be bound to the decision of the ordinary court. That is. And number second, equity follows the analogies of common law. Whatever the relationship between the equity law and the provisions of the ordinary law, if there is some resemblance, that if they have some concurrent jurisdictions, then the equity principles could also be applied by the authority, by the court, or by the judiciary. That is the basic concept of the equity policy law. And number third maxims, he who seeks equity must do equity. Number third maxims, he who seeks equity must do equity. Now, the maxim explains the meaning of the maxim. Simply stated is that if a litigant claims something by of equity, he must be ready and willing to grant to the other party that which belongs to that other party to equity. It says about the parties' conduct. What about the parties to the litigants, parties to the suit? If they seek equity remedy, equity justice, then they have to approach voluntarily to this. Their future transactions, their future conduct must be approached with the voluntarily. That is, they have to approach voluntarily from their own. That is, in these cases, in a court of law, we cannot impose uh, terms on the party suing. If he is entitled to a verdict, the law must take its own course. Here, if the dispute comes under the direct provisions of the ordinary law, if the verdict, if the judgment can be provided under the ordinary provisions of the law, here the provisions of the equity law, it will not intervene. It will not interfere. That is, yeah, these judgments, verdict, it will be in accordance with the provisions of the law. That is, but the principle that practice of equity court was entirely different. That is, here the maxim expresses that the person seeking the assistance of a court of equity must himself do equity. That is to act fairly. That is, but in case of the principles of equity, it is something different. Yeah, if the party they're seeking the equity justice, they have to act fairly. They have to approach it voluntarily. Here, the code of equity is a code of conscience. It is, and therefore, she said not merely the defendants, but the plaintiff also acts as a conscientious man would perform. Yeah, these maxims uh, provides about the obligation to both the parties, defendant or the plaintiff. They have to approach it voluntarily. When they seeking the equity justice under these maxims. That is, here these maxims we have seen in our Indian legal system in some welfare provisions. That is, some welfare tribunals. That is the MSCT court, motor accident claims tribunals, WC court, labor court, and the consumer redressal court. In these cases, yeah, that is the who he who seeks equity must do equity. This maxim, that is, whoever seeking the equity justice, that is the amicable solution, friendly solutions, speedy justice, remedial justice from the court. Then they have to approach voluntarily. Both the parties, they have to approach voluntarily on mutual agreements that they will accept the justice, whatever will be given by the prescribed authority. It comes under the maxims, he who seeks equity must do equity. That is, now the maxims number 4, he who comes to equity must come with clean hands. Number 4 maxims we are going to discuss. He who comes to equity must come with clean hands. Yeah, it provides about the parties past transactions, that is. What about the past transaction of the parties? Hmm. About this maxim provides here. The maxim is sometimes expressed in the form that he that had committed inequality shall not have equity. Hmm. Here, it means that the person seeking relief from a court of equity must not himself be guilty of a conduct with regard to the same transaction which would disentitle him to the assistance of the court. Here, while a court of equity tries to promote and enforce justice, good faith, uprightness, and fairness on the part of the defendants, it nonetheless stringently demands the same from the plaintiff. The plaintiff must concede all equitable rights of his adversary, which grow out of or are inseparably connected with the matter in dispute. Yeah, this maxim provides about the conduct of the parties who are seeking the equity principles. Ah, they have to comply with some procedure of the authority. That is, here, and this maxim is applicable to both the defendant as well as to the plaintiff. Here, now, these concepts, he who comes to equity must come with clean hands. Must come with clean hands. It provides that this maxim requires the plaintiff not only to be ready to do equity in future, but also to show that his first record in the transaction has been clear or fair and equitable. That is, here, does the maxim clean hands emphasizes the first conduct of the plaintiff. That is, if the first conduct of the plaintiff has been inequitable with regard to the transactions in question, he would not be entitled to any equitable relief. That is the parties, if they are sleeping on their own rights, these parties could not get the remedy of the equitable justice. That is, here, this concept we could see in the provisions of the section 89 of the CPC Civil Procedure Code. Yeah, this section provides about the settlement of disputes outside the court. Here, we could see in section 89 of the CPC. Yeah, this section also mentioned the related provisions of these maxims. That is, here, where it appears to the court that there exists elements of a settlement which may be acceptable to the parties, the court shall formulate the terms of settlement and if give them to the parties for their observations. And after receiving the observations of the parties, the court may reformulate the terms of a possible settlement and refer the same for arbitrations and conciliations, judicial settlement, including settlement through local adult, medicines. That is, here section 89 provides about this. Section 89 of CPC provides about this related maxims. Here, the court will given some opportunity to the parties. If there is some scope for settlements outside the court. Here, it is comes under the alternative dispute resolutions, which can be issued with by amicable, by mutually agreements. It saves the time. It is the speedy justice, remedial justice. It is, and it prevents the multiplicity of the proceedings when ambition is dead. About this section 89. That is. That's why if the court offer this opportunity, if the party themselves they have neglected this, if they wants to proceed in accordance with the provisions of law, then subsequently such parties cannot will not be entitled with the relief of equitable justice. They cannot be entitled the equity justice. Here, this maxim also related to the section 144 of the CPC, Civil Procedure Code. It provides about restitution. Restitutions. Here. Application for restitutions. The doctrine of restitutions is based upon the well-known maxim actus curiae neminem gravabit. That is, the act of court shall harm no one. That is. Thus, the doctrine of restitutions is based on equitable principles. In proceedings for restitutions, the court should pass an order consistent with justice to both the parties. The court has inherent power to order restitutions whenever justice demands it. It comes under the inherent powers. That is the judicial power, discretionary power of the judges, magistrate, court of judiciary. That is. That's why if they have seen that some parties they have been negligent about their rights, they had not been approached in compliance with the order of the court, then they could not shake the justice of equity principles. That is, here up to these maxims in these presentations we have discussed. I think we got a clear concept about it about these maxims of equity. Okay. Okay. Bye.